Today we'll be discussing the Connecticut Workers' Guide to Connecticut Paid Leave. In our agenda, we'll be discussing what is FMLA, CTPL, what are the qualifying reasons for leave, what do I need to know about CTPL, FMLA, applying for FMLA, CTPL, and we'll review additional resources. What is FMLA and what is CTPL? Public service announcement. CTPL is not FMLA. So what is FMLA? FMLA stands for Family and Medical Leave Act. There is a federal FMLA and a Connecticut FMLA. Both have been around since the 1990s. Both laws allow eligible employees to take job-protected time away from work for certain family and medical reasons. The Family Medical Leave Acts are implemented by employers and regulated by the state and federal departments of labor. FMLA does not provide income replacement. Employers may choose to adopt policies to provide for income replacement during the leave, continue to pay their employees the regular pay while they are out on parental leave, or require or permit employees to use their earned accruals like sick leave, vacation leave, or other PTO while they're out on leave, but they're not required to do any of these. The CTFMLA changed significantly on January 1st of 2022. To recap, FMLA provides job-protected leave for certain qualifying family and health conditions. So what is CTPL? CTPL stands for Connecticut Paid Leave. The Connecticut Paid Leave Act is a Connecticut law that creates a source of income replacement benefits for eligible employees who cannot work for the same reasons as FMLA. It does not provide job-protected leave. The Connecticut Paid Leave Act is implemented by the CT Paid Leave Authority, a quasi-public agency of the state of Connecticut. To recap, CTPL provides income replacement during certain qualifying family and health leaves. In order to have job protection and income replacement, an individual must apply for both FMLA and CT paid leave. Please focus to the Venn diagram in the center. This applies to most businesses with one or more workers in Connecticut. On the left, for FMLA, it does provide job protection, does not provide income replacement, and eligibility is after 3 months of employment. To focus to the right, Connecticut paid leave does not provide job protection, does provide income replacement, and eligibility is based on a minimum earning requirement and employment status. Qualifying reasons for leave and benefits. Medical leave, for treatment of one's own serious health condition. This includes serving as an organ or bone marrow donor and pregnancy. Bonding leave, to bond with a newborn or newborns or newly placed child, or for the time needed to process adoption or foster care placement. This applies to both parents, can be used any time during the 12 months after the birth or placement, and applies to birth, adoption, or foster care. Caregiver leave, to provide physical or psychological care or comfort to a family member experiencing their own serious health condition. Military caregiver leave, to care for a family member in the military who has experienced a serious injury or illness that occurred in the line of active duty in the armed forces. Qualifying exigency leave, to engage in certain activities arising from the fact that a spouse, child, or parent on active duty has been notified of an impending call or order to active duty in the armed services. And Family Violence Leave Act, which is job-protected time off which can be taken by a worker who is a victim of family violence to seek medical or psychological care or counseling for physical or psychological injury or disability, obtain services from a victim services organization, relocate due to such family violence, or participate in any civil or criminal proceedings relating to or resulting from such family violence. This is up to 12 days in a calendar year. Serious health condition requires both incapacity and treatment by a healthcare provider. Examples of this would be an overnight stay in a hospital, a chronic condition for which you see a healthcare provider at least 2 times a year, a long-term condition for which treatment is no longer effective. This would be Alzheimer's or terminal cancer, or incapacitation during pregnancy. This would cover prenatal appointments and complications during pregnancy. Connecticut paid leave and COVID or monkeypox. So can a worker receive Connecticut paid leave if they have been exposed to or diagnosed with COVID or monkeypox. Well, simply being exposed to or diagnosed with one of these is not considered a serious health condition. The worker may qualify for benefits if they meet the definition of a serious health condition, such as needing an overnight stay in a hospital or medical care facility, or being incapacitated for more than 3 consecutive days and requires the sick individual to receive ongoing medical treatment, or resulting in or worsening a chronic condition that requires treatment by a healthcare provider at least twice a year. The primary difference between caregiver leave under a federal FMLA versus the Connecticut laws is the definition of family member. So let's take a look at what that is. Under federal FMLA, an employee can take leave to care for a parent, spouse, or child who is under 18 or is over 18 and has a disability. Under the Connecticut laws, an employee can take leave and receive benefits for a parent, spouse, son or daughter of any age, sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity. Let's take a look at what that means. What does related by affinity mean? That's any person with whom the worker has a significant personal bond. That is one of like a family relationship. This is situation specific and depends upon the circumstances of the individuals involved. Examples of such relationships by affinity include, but are not limited to, an aunt or uncle who relies on the worker for unpaid care and has maintained a strong and enduring relationship with the worker, as typically seen between parents and their children or siblings, or an unmarried significant other of the employee with whom the worker maintains a familial spouse-like relationship, despite their lack of legal relationship to one another. What do I need to know about CTPL? Well, am I covered by CT paid leave? Who's a covered employer? Well, almost all employers who have one or more people working in Connecticut, and the state of Connecticut as to non-unionized employees. So who is not a covered employer? That would be the federal government, municipalities, unless their unionized employees have collectively bargained to participate. The same would go for local or regional boards of education, non-public elementary or secondary schools, railroads, governments of other states, and other sovereign nations. This is other non-covered entities as well. This is interstate truck drivers who work in Connecticut, but live in another state and thus don't pay income tax in Connecticut, and spouses of active duty military members who have opted to continue to pay taxes in their home state instead of where they are currently deployed. Other exceptions are sole proprietors and self-employed individuals who may choose to opt into the Connecticut paid leave program for themselves, but are not required to. So am I an eligible worker under Connecticut paid leave? You must earn at least $2,325 in the highest earning quarter of the first 4 of the most 5 recently completed quarters from one or more covered employers in Connecticut, and is currently employed in Connecticut by a covered employer or was employed by a covered employer in the 12 weeks immediately preceding the claim for benefits. And Connecticut paid leave makes the determination, not the employer. So how long will you receive CTPL benefits? Well, an eligible worker can receive up to 12 weeks of income replacement benefits in a 12-month period for all leave reasons, including military caregiver leave, except only 12 days of the 12 weeks can be used in connection with family violence leave, and an employee may receive an additional 2 weeks of CTPL benefits for a serious health condition resulting in incapacitation during pregnancy. So let's go over some of the responsibilities. This one is regarding Connecticut paid leave contributions. So the worker is contributing 0.5% of their FICA wages up to the Social Security contribution limit. The employer's responsibility is to create their account and deduct 0.5% of the employee's wages and remit those wages to CTPL with the required backup. For employers, if they have a payroll provider, they need to be ensuring that their payroll provider is withholding those contributions and remitting them to CTPL. Here at CT Paid Leave, we receive and reconcile those contributions, process over and underpayments, and impose penalties for noncompliance. In regards to the Connecticut paid leave claims, the responsibilities are as follows. The worker's responsibility is to submit their application in a timely fashion, either by doing it on the ctpaidleave.org website or by calling AFLAC. Provide supporting documentation for their claim, update their account with absence information and info about other sources of income, and of course, notify their employer that they've decided to take a leave of absence. The employer's responsibility is to complete and submit employment verification for their employee, notify their worker about their PTO policies, their call-out policies, and of course, anything including short-term disability, and refrain from discriminating and retaliating against their worker for taking leave. Here at Connecticut Paid Leave, we work with AFLAC to determine the eligibility, review supporting documents, and approve and deny claims as appropriate, calculate and pay benefits, monitor ongoing claims, investigate potential fraud, and impose penalties as appropriate. Connecticut Department of Labor hears appeals relating to denials of claims and to penalties. So what do you need to know about FMLA? Let's recap. FMLA refers to the law that provides eligible employees with the right to take job-protected leave for certain qualifying family and health reasons. There is a federal FMLA and a Connecticut FMLA. So am I covered under FMLA? Well, to be covered under federal FMLA, this is employers who have 50 or more employees within a 75-mile radius. This is governmental entities of any size, including federal governments, state agencies, towns, schools, railroads, and governments of other states. To be covered under Connecticut FMLA, this is almost all employers who have one or more people working in Connecticut, and the state of Connecticut as to all state employees. So who's not covered under Connecticut FMLA? Well, this would be the federal government, municipalities, local or regional boards of education, non-public elementary or secondary schools, railroads, governments of other states, and other sovereign nations. So is my employee eligible for leave under FMLA? Well, under federal FMLA, if the employee has been employed by the company for at least 12 months and they have worked at least 1,250 hours in the 12 months immediately preceding the leave, they would be eligible for federal FMLA. In Connecticut, if the employee has been employed by the company for at least 3 months immediately preceding the leave, they would be eligible for Connecticut FMLA. There is a no hours worked requirement, and the employer makes these eligibility determinations. So eligibility for job protected leave can be worked in several different ways. So an employee can be eligible for federal FMLA leave only, Connecticut FMLA leave only, both federal and state FMLA running concurrently, neither federal nor state FMLA, but job protected leave as a reasonable accommodation, or no job protected leave at all. So how long is the job protected leave? Well, federal FMLA is up to 12 weeks of leave in a 12-month period for all FMLA leave reasons, except up to 26 weeks of leave in a 12-month period for military caregiver leave. For Connecticut FMLA, it's up to 12 weeks of leave in a 12-month period for all FMLA leave reasons, except up to 26 weeks of leave in a 12-month period for military caregiver leave, and an employee may receive an additional 2 weeks of FMLA for serious health condition resulting in incapacitation during pregnancy. And Connecticut Family Violence Leave Act is up to 12 days in a calendar year. So let's review the responsibilities regarding FMLA leave claims. Worker needs to notify the employer about the need to take time off away from work in a timely fashion. So basically, if you know that you're going to be taking time off, please let your employer know as soon as possible. Obviously, if you've had an accident of some sort that's not foreseeable, you can't do that, but as soon as possible. Submit your FMLA application as necessary. If there is an application, you would know this because you would go to your employer and just simply ask. Provide your employer with the supporting documentation. This is generally a med cert, a medical certification that you would get from your doctor, and comply with your employer's attendance and call-in policies. The employer needs to establish the leave policy, including rules about PTO usage, post the FMLA poster, process leave requests, monitor leave usage, manage the worker's return to work, and refrain from discriminating and retaliating against the worker for FMLA usage. Here at CT Paid Leave, we have no official responsibilities relating to FMLA on the state or federal levels, but we do provide information about FMLA as a part of our Connecticut Paid Leave training. The Connecticut Department of Labor and federal departments of labor promulgate regulations regarding FMLA and guidance to workers and employers about their programs and investigate complaints regarding denials of FMLA claims and discrimination and retaliation. Both of these hyperlinks are active, and you will receive a copy of the deck with your training. And you can go to these links and reach out to these departments of labor to get more information. So applying for CT paid leave benefits. How to apply? You can start your claim for benefits by going online to our portal at ctpaidleave.org. Applications are also accepted via telephone at 877-499-8606. You will need to provide documentation to support your claim. Remember, you must notify your employer if you apply for CTPL benefits. You will likely need job protected leave under FMLA. You will need to apply to your employer directly for FMLA. Here's a quick overview of the claims process of a timeline from case creation to final decision. The employee would start their application, submit their identity verification documents to AFLAC, and the employer would return the employment verification form to AFLAC. The employee would submit their claim-specific forms to AFLAC, and at the point of all forms being received to AFLAC, the case would be considered complete and the review process would begin. There's a 10 to 15 days that have elapsed from the date that all forms were received where AFLAC would issue a decision. There is some more information and resources from the employee rights poster, a RAC card, employer toolkit, HR toolkit, employee fact sheet, and a notice of employee rights. All of these links are active, and you can click on them and download the color PDF. And for questions about the Connecticut Paid Leave Program, you can find more general information by visiting our Contact Us portal. Questions about your already filed Connecticut Paid Leave claim, you can log into your account through the CT Paid Leave portal or call AFLAC. And for more questions about Connecticut or federal FMLA, you can go to their websites and you can reach out to them for more information. Thank you so much.